Today is Wednesday, March 3rd, 2021, and this is a Lane Transit District Board of Directors work session. Today we'll be meeting from 5 to 6:30. So I am going to start with our roll call. So Joshua Scove.
Here.
Thank you, Josh. Stephen Yett.
Present.
Thank you, Stephen. Don Norden. I see Don on here. Don, you might be on mute if you want to take it off mute and say here. Well, I will acknowledge that Don is on the call and he appears to be here. Right now we are missing Emily Secord, and I will make a note if she joins. And then I'm just gonna move on to comments from the board president. So I just wanted to note, just so we're all aware, that we have 2 new board members. We're waiting for their assignments to be finalized. And so I just wanna acknowledge and recognize that they're both attending this work session today. Since their appointment is not finalized yet, they are attending as members of the public. So I just want to say thank you to Michelle and thank you to Susan, who are taking the time to be here to absorb this really important information. And if it's appropriate, and I'll kind of look to Camille and AJ's guidance on that, if they have any questions, kind of how we field that. So I'll turn that over to the experts. But thank you again to Susan and Michelle for taking the time to be here this evening. Okay, great. So AJ, do you have any comments for us tonight?
I do. I have an announcement. I wanted to make sure I got this information to the board in a timely fashion, so I did not wait to the regular board meeting. But we, as the vaccinations became available, we had a situation in which there was a ride source vehicle that waited in an extended line for one of our riders to get a vaccine. And it was really an unusual situation that the driver had not experienced before. So some lessons learned from that experience was that we contacted the county. First, we did our research, making sure we're working within our state and federal guidelines. And then the team reached out to the county about how we can do this better. And I will say the county has been an exceptional partner through this pandemic, and this situation is no exception. They have stated that anytime they see one of our ride source vehicles, they will actually deploy a vaccinator, is what they're calling them, over to the vehicle and actually administer the vaccine on the vehicle where the person is already seated and comfortable. And then the driver will, of course, just wait the required observation period, which is minimal because they're prioritizing us. And that will allow us to be able to really get those vehicles moving quickly. I will say the county is also waiving the appointment times. And by waiving those appointment times, it allows us to group more than one person and really get multiple people on that vehicle. So I just wanted to make sure that the board knew the coordination that was happening around that. And one additional note on that, due to the importance of having our community vaccinated and the large impacts on all of us, including our transit services, the team has also offered that if necessary, we would even provide support to the rural areas in taking our vehicles to provide some type of transportation. So we're really trying to take a proactive approach and working closely with Lane County's Public Health Department. So felt that was important, given that the fact that we did have a situation that did not go as smoothly as we had hoped. But between the county and LTD team, we were able to figure it out. So just wanted to make that. Thank you so much for allowing me to make that announcement.
Thank you so much for that information, AJ. And I encourage anyone in this group, if you have additional questions, to send an email. We have a really, really tight schedule today because Kristen has a lot of material to present. So Josh, I want to acknowledge, I see your hand up. But we've got a lot of ground to cover. Kristen already condensed these two trainings into one 90-minute session. And I'll also be brief in our next agenda item. So once again, feel free to send an email and include the board members, Josh or anyone else that's wanting to continue that conversation. Okay, great. So I'm going to move on to announcements and additions to the agenda. Does anyone have anything? Okay, great. Thank you. All right, so next up is the ad hoc committee for the general manager evaluation process. Like I said, I'll keep this really brief. We had talked about this before, as everybody is aware. We kind of revamped things this past year, which was a lengthy process, and there was a lot to be considered. Once we dissolved the HR committee, kind of everything regarding the general manager's evaluation was subject to the full board. So we tried to get together general manager's evaluation. We're very much already well into this fiscal year, and AJ's been making progress on that evaluation. So we're not changing this current one. What we're really going to be focusing on is the future year's evaluation process, kind of that timing. You know, of course, all of this ties into the contract, which we're going to be looking at as well. And then we're just really trying to get together a very smooth future evaluation process and really put together the best resources that we can for that. And so just to keep in mind, we'll kind of have the role ironed out a little bit more at our first committee work session. But it will meet for the first few weeks starting in March, starting this month. And then we'll kind of take a little bit of a break. And once we do the contract negotiations, then we'll be meeting again after that. So with that being said, I have appointed to that committee myself, Joshua Scove, and Michelle Weber. So we will be the ones on that committee. And if, once again, any questions, please feel free to let me know. I'm happy to explore that further with you. So once again, Kristen's got a lot to cover. We're so excited to have her today. You know, it's a little harder to do these things on Zoom, right? Because it's such an interactive process. But Kristen, thank you so much for flipping the format and taking the time to teach us some really important things so we can be the best board members that we can be and be the best representatives of our sub-districts possible. So without any hands up on anything I've said so far? Awesome. Thanks, you guys. All right, Kristen, I am going to turn it over to you for our training on ethics and public meetings law. So thank you so much.
Great. So I'm going to share my screen in just a minute, but I was going to ask Camille if we could pull in Susan and Michelle. We're not going to deliberate about anything. This is just a training, and I am trying to make it as interactive as possible. So I'd really like them to be able to participate with the rest of the board. Great. Thank you. Okay. And then let me get this set up. Okay, can you all see that in a full size format? Okay. Okay, so thank you all for having me today. I'm gonna do a presentation on two topics, government ethics law and public meetings law. As Caitlin alluded to, these are normally separate presentations. So just because of your scheduling, we're condensing them into one, which means for you, I am hitting the high notes of these so that it is not a super long presentation, okay? So as most of you know, I'm Kristen Denmark, your general counsel, and welcome to our soon-to-be new board members. I'm really glad that we are doing this with the new board members because This is a really important introductory topic for new to LTD board members, but it's a topic that we revisit with our board members, every year or every couple years. And so I know that Michelle and Susan are probably otherwise experienced board members. LTD has a few things that are unique in terms of especially government ethics law because of the federal funding source from the FTA. So there's a different layer with LTD than with a lot of other entities. So today we are going to go through first government ethics law, and we have 3 topics under that: conflicts of interest, gifts, and use of office prohibition. And then our second topic, I think we'll spend more time on the first one. And then our second topic is public meetings law. And that's just one topic, but I'm going to go over the law and then make some recommendations to you. Okay, hang on just a second. The way I practiced this last night on Zoom, and of course it's showing up differently on my computer. So hang on, I just want to get it. It's not showing me my notes. Okay, hang on. Give me just a second, and if not, I have it printed, so I'm good to go. Okay, so the way that I always present government ethics law is in the form of a pop quiz. And so normally when I do this in person, I bribe you all into answering me by giving out chocolate or candy or some small prize. And so I cannot do that because of the manner in which we're presenting, but I decided that I could still incentivize your participation or bribe you into participating through awarding prizes and making this a competition. So what Camille does not know yet is that I need someone to help me regulate this because I can't see my presentation and everybody at the same time. So what we're going to do to learn government ethics law is we're going to have a pop quiz. We're going to have 5 questions, okay? I have 3 prizes that are available to be mailed out to board members who get the most correct answers. I'm loosely making up some ground rules that I and Camille will be the judge and jury on as we go along. So you have to wait till I'm done reading the question to raise your hand. You can raise your hand via the hand icon or an actual hand. And if you have correctly answered 2 questions, we're going to call somebody else first. And this is for, all our current board members, but also Michelle and Susan, feel free to participate with us as well. So we're going to first go over a little bit of the law, and then we're going to do a question. And so I think this part's going to take us more than half of the presentation, and I hope that it keeps you awake and hopefully you don't fall asleep for part 2. Okay. So Camille, is that okay? Are you able to help me, or should somebody else do that?
Oh, no, I can absolutely help you. Just tell me what and when.
Okay. I'll let you know before we have a question. Okay, so we're going to start with conflicts of interest when federal funds may be involved. And before I get to that, what I'm going to say is normally when I do my presentations, I'm happy to take questions at any time. But I'm not going to do that since we're doing a pop quiz. So I'm actually asking you questions and you don't get to ask me questions until later. Okay. So conflicts of interest when federal funds may be involved. Okay. So what that means is that when a project or contract is funded or might be funded with funds from the FTA, that these are the rules that apply in terms of conflicts of interest. And so there's a lot of words up on the screen. This is almost always going to apply when you're doing contract award. There might be an exception to that, but that's what the FTA anticipates. And so it's when the board is either selecting, awarding, or administering a contract supported with assistance from the FTA. Okay. And it is if a conflict of interest, and I'm going to note here, real or apparent, would be involved. FTA does not distinguish between what they call real conflicts or apparent. And such a conflict arises when the board member, any member of the board's immediate family, the board member's partner, or the board member's employer or prospective employer, and then has a financial or other interest in the entity awarded a contract with LTD. Okay, I will tell you that none of these terms are defined, and the FTA interprets them extremely broadly. Okay, so they're trying to catch just about everything that could possibly be a conflict by interpreting the words broadly, whether it's a real or apparent conflict. And if you fall under that broad definition, then you have a conflict of interest for a FTA funded project or contract. Okay, so I'm going to pause for just a minute. I'm going to let you absorb that for a minute because we're about to go on to our first question. Okay. Okay, board member Megan is married to Bob, and Bob works as a finance manager at Speakeasy, a marketing consulting firm. LTD has solicited requests for proposals for an advertising campaign. Bob did not participate in preparing Speakeasy's proposal. He would not provide services under the proposal. So a team evaluated the proposal, and Speakeasies would be most advantageous to the district. So LTD staff is recommending the board authorize the general manager to enter into a contract with Speakeasy. Can board member Megan vote on whether to authorize the general manager to enter into a contract with Speakeasy? What is our answer?
I agree with Dawn. The answer is no, but my buzzer's not working here. My Jeopardy buzzer's not working.
It's just a hand, and then Camille's going to call on whoever she thinks is first, which she might be biased. I don't know. It's Camille gets to.
Well, Don Norton answered first, and he said no. Thumbs down.
Okay, so Dawn, I need you to tell me why you think the answer is no.
Well, it could be a perception issue. And this person sits on the board and their partner is going to get contracted and money from the federal government. So whether they actually engage in any financial stuff or not, it becomes a perception thing.
Okay, so so the answer is no, but we're gonna go step by step through it to understand why the answer is no, okay? So hang on, move your little faces to the other side so I can see this. Okay, so Bob is board member Megan. So Megan's our board member and Bob is her husband. And so he's her immediate family. Remember the word financial or other interest in Speakeasy? That is a very, very broad phrase. And it is interpreted to mean, hey, if your employer gets a contract or a benefit, you have an interest in that. It doesn't matter if you're paid directly because the company got the contract. Bob's compensation, if you remember, he's a financial manager. So his compensation might not be tied at all to getting this contract with LTD. But that phrase is very broad and it is interpreted broadly, okay? So Bob has an interest in his employer getting the contract. And so that actually rises to a conflict of interest, okay? And then our second question is, okay, what does Megan do? She has a conflict of interest. So whether it's a real conflict or an apparent conflict are the words that FTA uses, she is prohibited from participating in the award, okay? So what that means is that Megan when this topic comes up at the meeting, before there's any discussion, she should announce both that she has a conflict, and she should shortly describe what that conflict is. And then she should refrain from any other discussion, and she should not vote on it, okay? So the reason that I like to use this example is because without knowing what the FTA rules are about conflict of interest, this seems very tenuous to me. It's very broad, yet it is captured within FTA's definition of a conflict of interest, okay? Okay, does Josh have a question, or is that a hand up from prior? I can't tell.
I was just wondering if you wanted to say something about how, although this is focused on the use of federal funds, maybe this is good practice generally. I don't know if you want to say anything about that now. Or if we can
So we are going to get to the conflict of interest under Oregon law, because I want you, so this is what makes it challenging to be an LTD board member. You all are governed by Oregon law, and where receipt of federal funds are involved, FTA law or FTA rules, and they are similar but different. And so our next thing that we're going to go on to is Oregon law. And then we're going to talk about perception, which is what Dawn hit on also. Okay, did anybody else? I can't see all of you at once. So I couldn't tell if anybody else had a hand. Okay. Okay. So we're going to go to conflicts of interest under Oregon law. So Oregon, remember how FTA just had one rule for what they call real and apparent? Well, Oregon likes to have a lot more rules and a lot more definitions. And so there is, if you'll see in the text, I have these words, actual and potential, and would and could. So the definition for an actual conflict of interest under Oregon law and a potential conflict, the only difference is the word would and could, okay? So in an actual conflict of interest, it means any action or decision or recommendation by you all as board members, the effect of which would be to private pecuniary benefit or detriment of you all as board members, of your relative, or any business with which you or your relative is associated, okay? A potential conflict of interest is that same definition, but the effect of which could be to the private pecuniary benefit or detriment of you, your relative, or any business with which you're associated, okay? So then in Oregon, there are different, you take different actions based upon what type of conflict you have, okay? If you have a potential conflict, at the beginning of the meeting, before there's discussion, you will say, I have a potential conflict because X, okay? That's what announcing the nature means. But you may participate in the discussion and you can vote, okay? And so that's different from the FTA where they would call that an apparent conflict and you would be prohibited from any action, okay? If you have an actual conflict in Oregon, at the beginning, you're going to announce the nature of your conflict, and then you are going to refrain from both discussion and voting. There is even a very, very small carve out if you have an actual conflict of interest when you can vote, but that is only if there are not enough members to make up a quorum on the board. So I've never actually seen it happen, but you can see that the FTA prohibits more if there's a conflict. Okay, so I want to make sure that you understood there's different rules, okay? Okay, so Dawn is winning with 1 point, and we are going to go on to question number 2. I believe I mentioned I have prizes for 3 board members. However, if we have excellent participation, I can make more prizes available. Okay, question number 2. Board member Charlie's brother, Dante, owns a small sheetrock contracting business. And LTE is going to update its administrative building. And staff presents options to the board. We can do an invitation to bid for a general contractor, or we can manage all the smaller contracts, which would include a contract for sheetrock work. Dante told Charlie he would put a bid in on the sheetrock work if the opportunity arose. So for those smaller contracts. Can board member Charlie participate in the discussion regarding updates to the administrative building? Camille, is there anybody to be called on?
Josh just raised his hand.
Okay.
Oh, I was just doing it preemptively because Don answered so quickly before I was insecure.
Well, you have a 50-50 shot.
Oh, I thought I had to give the rationale. I give the rationale. No,
Just start. I'll help you along.
actually, I'll just say he may participate in the discussion.
Okay. And so do you think that's because he has a potential conflict and not actual?
Yes, it's because he has potential, not actual.
Okay. Okay. Good job. So Josh gets 1 point because the answer was yes. And we're going to go over why. Okay. So first we want to say, okay, Charlie, his brother, Dante, okay, but it's his relative's business, okay? Remember, business with which you or a relative is associated, okay? And so that fits within that category that we have to analyze. The discussion regarding what contracting option to pursue could result in a private pecuniary benefit to Dante's business. I mean, he said he would submit a bid, but also we don't know that he would submit the best bid. We don't know that it would win, okay? And so it's potential that it could result in it, but it's not actual. Okay, so that is a potential conflict of interest, which means Charlie should publicly announce the nature of his conflict at the beginning of the discussion, but he can participate in the discussion and he can vote. Okay. Okay, so we're going to do back-to-back questions. This is 3 of 5 of our quiz. Okay, so all the hands are down, so good. Give me just a second, I'll move on. Okay, question 3. LTD intends to purchase undeveloped property to create a park and ride facility. The property is owned by Brian Kim. Brian is Nancy Neat's stepbrother. Nancy's husband, Mark Neat, is the LTD board member. LTD staff recommends that the board authorize the general manager to purchase the property from Brian Kim for $350,000. Can board member Mark vote on whether to authorize the general manager to purchase the property from Brian Kim? Camille, who are you going to call on?
Sorry, Josh.
Okay.
Oh, no. Someone else should go. That's not fair. Keep it moving. I'm happy to wait.
Come on, Josh, you can do it.
Okay, no.
I
Mark,
raised my hand.
Oh, yeah.
before
Sorry.
Josh.
Oh, Caitlin, you were off my screen.
I'm sorry, Caitlin, I didn't see you.
Oh, I'm not on your screen. Come on, y'all. Okay. I say yes, it is a conflict of interest.
Okay, why do you think so?
Well, I would say, let me look at my notes from Oregon law.
So if you think it's a conflict of interest, so my question was, can he vote?
Well, I think, let's see, so I would say it's a actual conflict of interest means any action or decision, or which is voting is a decision, acting in the capacity as a public official, which could or would be beneficial to the person's relative or a relative of the person associated. So I would say yes, just because of since it's using the words decision, because it's a vote.
Excellent job. So why I like this question is because it shows how broadly Oregon interprets the word relative, okay? So when we're analyzing this, we're thinking about who is the board member, okay? So the board member is Mark. It's not Brian isn't his stepbrother, it's his wife's stepbrother, okay? And so the definition of relative, and also I'm not expecting you guys to remember these details. I just want you to know high enough, like, Oregon thinks everybody in my extended family is a relative, okay? So is your spouse, your parent, your step-parent, your child, sibling, step-sibling, son-in-law, or daughter-in-law of you or your spouse, okay? So all those people are captured within a definition of relative. So because Brian is the step-sibling of Nancy, Mark's wife, that falls under the definition of relative, okay? So that's our first question. And then Mark's vote to purchase the property would be, so it's an actual conflict, it would be to the private pecuniary benefit of Brian, a relative. That's an actual conflict of interest. So Mark cannot vote. He needs to announce the nature of his conflict and refrain from participation. Okay, so I see a hand up from Stephen.
Thanks, Kristen. Just want to clarify point 3 where it says he is prohibited from participating in the award.
Oh, thank you. Yeah.
Versus no, where he should refrain from further participation. So is he allowed to discuss this with the other board members, or just keep?
When there's an actual conflict of interest, you can't discuss it. So you should, at the bottom here is really the best. He should publicly announce the nature of his conflict, refrain from any participation besides announcing the nature of his conflict, and do not vote. Okay.
Thank you.
Yep. Okay, so do we have any other questions on this one before we move on? Okay. Okay. So that we're going to finish up conflicts of interest before we turn to our next topic under government ethics law. And here's just my little spiel to you all. For disclosure requirements, help us help you. So we're governed by 2 things. You all are governed by Oregon government ethics law, okay? If you violate Oregon government ethics law, the penalty accrues to you as an individual, okay? There is the potential for fines up to $10,000 for very serious violations. And so we can't help you if we don't know information, okay? And then the other layer of this is that from, LTD gets audited by the FTA, there's kind of annual certifications, and then there are audits for specific departments or specific topics. And those happen from time to time, and we don't know about them until they're about to happen. FTA does and has in the past looked at LTD contracts to see if any board members have conflicts of interest. And when that happens, that becomes a finding on an audit that is disfavorable to the entity of LTD. And so we are really in this together. We don't want you all to violate the law and get an individual penalty to you. And we also don't want LTD to get findings on an audit with FTA. And so my last piece to tell you is that, family members change over time and businesses with which you are associated change over time. So it's not like you disclose it when you become a board member and potentially 8 years later, all that information is still the same, okay? It's a fluid thing. And so you just need to have that in your mind that you're analyzing that, every time that you're voting on something. And I think most of the time you're going to know it, but, I just want to give you enough information so that if it happens in the future, you can issue spot enough to say, I need help to see what I should do. Okay, so that's the point of this presentation. Yes, Stephen, do you have a question?
I do, and I'll be quick.
Sure.
This is all for the situations that are coming before the board. What happens if a board member is aware of contracts that are below the $150,000 threshold that the GM has to bring in front of the board, but the board member has a conflict as we're discussing here?
So a conflict can only arise on a matter that you are making a decision on, okay? So if you might remember in the past that the board would authorize, I don't know if it was the delegated authority, but it was some type of like larger report. And within that, there were expenses to Willamette. And at that time, board member Kate Reed worked at Willamette. And so it wasn't like an individual contract that was being approved, but that lesser contract was within that kind of bulk package. So she would always announce the nature of the conflict and she would not make a decision on that. And so if you're, I don't think you approve the delegated authority reports, it's just for your information. But if it were like in the consent agenda, okay, and if it wasn't just one item, you would need to recuse yourself if it were an actual conflict. So it's only going to rise to the level that you're making a decision on something, but you just need to make sure that it's not kind of buried in something else that you're making a decision on, if that makes sense.
It does. Thank you.
Okay. Okay, so we're going to go on to our next topic under government ethics law. Okay. And so this is gifts. And so again, we're going to go through a few examples. We're going to learn what a gift is. This is Oregon analysis. And so FTA doesn't have a gift analysis. Theirs is just a conflict of interest analysis. And so this is just Oregon law that we're learning here. Okay. Okay, so under Oregon law, you'll notice that the definitions are long under Oregon law and the tests are long too. So I'm trying to give you the highlights here. A gift is something of value that's given to either a board member, a relative, or a household member. It's going to have the same definitions for those that we talked about before. It is for free or discounted, and it's not offered on the same term to others. The word others is generally interpreted to mean the general public, okay? So then if you are offered something that meets this definition of a gift, we're going to go through an analysis to determine whether you can accept it. And it is a 4-part analysis. So the first thing you're going to start with is you're going to ask, do I know who gave me the gift? And that would be, we're going to call that the source, okay? And so the second thing is you ask, does that source have a legislative or administrative interest in you? Okay. And a source has a legislative or administrative interest in a board member when the source has an economic interest distinct from that of the general public and in any matter that is or would be subject to the decision or vote of the board member. Okay. I'm just going to make a little bit of a fine point here, and then I'm going to summarize this. When you're doing a gift analysis and a conflict of interest analysis under Oregon law, it is unique to you. So you are asking here, does this person giving me, board member, this gift have a financial interest in any matter that I'm going to vote on? Okay. Your answer for that might be different than a staff person's answer because you all can vote. Okay. But maybe the particular staff person has no decision-making authority. Okay. We're not looking at it from the perspective of LTD as the entity. We are looking at it from your individual perspective. Okay. Now, I'm going to simplify this language in a way that you will probably remember. This whole section is about, is someone trying to buy your vote? Are they trying to give you something to make you vote a certain way? That's what the gift analysis is about, okay? It's about a third party trying to give you something because you're about to vote on something that's going to impact them in a financial way. So if you remember nothing else, that is what all this gift stuff boils down to, okay? So if the source, the person or entity giving you the gift has a legislative or administrative interest in you, we got to continue the analysis. If they don't, you may accept the gift. Okay, Josh, I'm going to ask for your question, but I might not answer it because we're going to do a pop quiz.
Well, I just, that's legit. The second bullet point does not like grammatically follow on what's above. So I actually just want to clarify, because you say, when the source has in any matter that is or would be subject to the decision or vote of the board member.
Yeah. So they have a financial interest in something that either is currently on the board agenda or might be on the board agenda for a vote.
So it's a financial interest.
Yeah, I mean, economic interest really means
Yeah.
financial. Yeah.
Okay, sorry. The way it's written, it seems like the first part is an economic interest and the second part is something else. But in both cases,
I mean, so it has to be those two things. So they have to have it. We're talking about money here. So they have a financial interest, and I think you'll see this through our examples. They're either going to be financially harmed or financially benefited by a decision that the board is or may in the foreseeable future make. I mean, does that make sense?
Yep, that's great. Thank you.
Okay, so if we know who the source is, number one, and the source has a legislative or administrative interest in you, then you have to go to number three. Does the gift fall under exception that allows you to accept the gift? There are a lot of exceptions. We're going to talk about a few of them. It's a pretty long statutory list that doesn't really make common sense, but that's what they are. We'll talk about a few of them as we go through the examples. So even if someone has that legislative or administrative interest, if there is an exception, the way it works is the exceptions technically exclude that from the definition of a gift. Okay, so you can accept it. So if it doesn't fall under an exception, so it is a gift, the person has a legislative or administrative interest, then you get down to the last question, which is probably what most people are most familiar with, $50 gift limit, okay? You can accept $50 of gift per year, per source with a legislative or administrative interest in you, okay? Okay, so I know that's a lot of information, and trust me, it can be really confusing. So we're going to do our last two questions in our pop quiz about gifts to help work through some of this stuff. Okay. Okay. Are we ready? Okay. We have all the hands down. Okay. Okay. So board member Abel is acquaintances with Isabella, who owns Bella Boutique. At the next board meeting, the board will vote on whether to expand LTD services. And if the expansion goes through, if the board votes to approve it, it would require the LTD take 8 feet of property in front of Bella Boutique. The week before the vote, Isabella offers to purchase a seat at the Citizen of the Year dinner for board member Abel. The seat is $60, represents the cost of admission and food. But board member Abel is going to attend the dinner in his official capacity because he's representing LTD to present an award to a community member. Can board member Abel accept the gift of $60 for admission and food at the Citizen of the Year dinner? Camille, who are you calling on?
Caitlin. I'm scrambling to unmute.
I immediately say, no, board member Abel cannot accept the gift of the $60 for admission because they are there in their professional capacity. And Isabella is going to want board member Abel to vote a certain way to not take that 8 feet of Isabella's property. And so there's a financial interest because it's dinner and drinks that's being paid for. And then it also would have to do with the vote of the 8 feet.
Okay, Caitlin has
That's both boxes in my opinion.
Okay, she has excellent reasoning, but the wrong answer. So we're going to talk about why her reasoning is good, but legally the wrong answer. So Camille, she gets a half point. So for her good reasoning. Camille, who are you going to call on? No pressure.
Dawn.
Okay.
Well, I'm saying, yes, it doesn't indicate in this presentation that Isabel even is paying the $60. If the board member is attending the official capacity representing the board or the district, Isabel is not, it's not a conflict at all, unless
So assume that
the $60 for something else, it doesn't mean anything.
Okay, assume that she's paying for it, but he is going to attend presenting this award in his official capacity.
So we're assuming that
She bought
Abel
it.
is not going to go to this thing unless he gets $60.
Yes. We don't have a page and a half for the example, so yes.
Well,
See, they make them harder as the quiz goes along, you guys.
Susan just
Yeah.
raised her hand.
I think,
Susan raised her hand.
all
Okay.
right, let somebody else try.
Okay, I'm gonna give Dawn a half point. Susan,
I think the
welcome.
key is
Thank you for
that
raising your hand.
I think it's because it says the food and the cost of admission. So I think when you break those two down, it's under the $50.
Oh, okay. You guys have very good guesses. I'm gonna give Susan a half point. Okay. So it's not really fair because I didn't teach this to you. Okay. So Abel can accept the gift because, so we're going to go through. The source is Isabella, a Bella Boutique. Okay. She has a legislative or administrative interest in board member Abel. So if her property is, going to be taken, she's going to be compensated for that. It might harm her business. And so she definitely has a financial interest. Okay. However, admission or food when a board member is acting in their official capacity is excluded from the definition of a gift. Okay. So this is why I say I don't remember this stuff. I look at the statute. Okay. So, the point of all this is you need to, if you're being offered something, you need to check in to see whether you can accept it, because sometimes this stuff doesn't make common sense. Okay. So in this analysis, Abel can accept the gift, even though it's more than $50, even though it's from a source with an administrative interest, because this falls under an exclusion. I'm going to go over a couple of pertinent exclusions from the definition of a gift. We also have in the materials, I'm going to provide you a packet. I don't mean it to be overwhelming. I'm going to provide you just some materials that if you ever want them, they're there, and Camille's going to have it. But I also want you to have resources. And one of the things I'm going to give you is the previously adopted board policy regarding ethics. And in that policy, we list some of the pertinent exclusions from a gift. Okay. So I'm going to read through some of the pertinent ones, but there's a pretty long list. Gifts from relatives or members of the board member's household are always excluded. An unsolicited token or appreciation of award or award of appreciation with a resale value of less than $25. An admission provided to or the cost of food or beverage consumed by a board member or a relative when you're acting in your official capacity and representing LTD. Okay. And then there's a few others. I'm going to again remind you that gifts analysis only applies when a third party is purchasing these things for you. Okay. It does not apply when LTD would be purchasing these things. That is LTD can't give you a gift. They can't give board members a gift. They can't give employees a gift. Okay, so our last provision that we're going to get to is how to analyze when LTD is the source. Okay, and so there are things that you can accept from third parties that you can't accept from LTD. Okay, so then my last point on this is what Caitlin said and what maybe Josh and Dawn raised earlier. Just because things are legally permissible doesn't mean that they make good sense from a public perception standpoint. Okay, so you all are public officials, and something that, you know, I always remind my boards about is, what if this was printed on the front page of the Register Guard? What would that look like? And that is not a legal decision. Okay, there are things that you are legally permitted to do that might not look great. So that is a personal decision for you all individually to make, but I think this is a good example potentially of that, that it might not look good for Able to accept that from Isabella, and that's what we heard from some of you all, okay? Okay, so then our last question.
Kristen, sorry,
Yeah.
super duper fast.
Sure.
I understand that this is exempt. I mean, it's an exception. But is there no additional reference to any dollar threshold here? I mean, like admission and food could get pretty steep. I mean, that could be a four-digit number rather than a two-digit number. So.
Not that I'm aware of. Yeah.
Okay.
So it's not capped by that $50, and it's not that I'm aware of.
Okay.
So yes, it could potentially be much, much more expensive. And that is where the public perception issue really comes into play, is that there are things that you can legally do that might not be good from that perspective. It's a good question.
Thanks.
Okay, so right now we have a tie with Dawn having 1.5 points and Caitlin having 1.5 points. Josh has 1 and Susan has 0.5. So again, we're going for top 3, but if the excellent participation continues, I will award more. Okay, so our last one is going to feature our same characters. Board member Abel knows Isabella, who owns Bella Boutique, and the board's going to vote. The proposed expansion is going to take Bella's property if it goes through. So the week before the vote, Isabella says, hey, Abel, would you like to play some golf? Just for fun. The fees are $100 and she's going to pay for it for Abel. So the 2-part question is, can Abel accept the $100 in paid fees? And if he can't, can he pay $50 and accept the other $50 as a gift? Camille, who are you calling on?
Well, I'm going to raise my hand if nobody else does, but I'm trying to work a like 5-way tie so we can all get prizes. That's really what I've been angling for.
Well, Dawn is not holding back, so
he never put his hand down, so I think he could be disqualified.
Okay, I'm going to let Camille handle this one. She's up to the challenge. I can't see everybody. I don't know where Camille went. Is she still there?
She's there. Camille.
I believe she can't hear.
Is that AJ?
Yeah, that's me. I'm here.
So should you call on AJ?
Okay, I'm gonna call on, let's see, any of our new board members. There we go, Susan, there you go.
Okay, Susan, she's trying to make it a tight race.
I would say no and no.
Okay, why?
Well, because the $100 exceeds the $50 gift, but she's going to be having an issue that's coming up for a vote that has financial implications for her.
Okay. Okay, she's right. Sorry, Josh, I see your hand up. That's okay. So this actually is a question that has come up across multiple clients, the question of splitting the gift. And so I wanted to make sure to include this. So, you know, Isabella is the source. She has a legislative or administrative interest. I'm sorry, but golf for fun does not fall under an exception. The gift is more than $50. So Abel can't accept it and he cannot split the difference. So it's an either or. You're either accepting the gift or not accepting it, okay? Also, another thing that I would like to remind you is you can't unwind a gift that you have accepted, okay? So the analysis that you need to do needs to happen before you receive the gift. You know, you might try to give it back, and you might give it back, and that might be totally fine, but that's not how the legal analysis works. So you can't split the difference. You can't accept part of the gift. You can't unwind the getting of the gift, okay? So I need to make sure that you at least remember the high points so you know to ask before you say, yes, I will take that. And that is what I'm trying to get through today, not all these details, okay? Okay, so I just want to say that we have an awesome three-way tie for first place. Susan came from behind with the last minute win, you know, tie to win with 1.5. Caitlin has 1.5 and Dawn has 1.5. So they will definitely be receiving prizes. And I'm also going to award one to Josh because many times he let other people answer and he got 1 point. So he was close behind. Okay.
Josh gets like Miss Congeniality.
Yeah. Okay. So I will be sending those out probably later this week or sometime next week. And then if we continue on this track, I don't have points to award, but I might just, you know, give some more out too.
And Kristen, make sure you keep those gifts under $50, please.
Don't worry, they're way under. But that's a good point. That's exactly right. Okay, so we're doing fine on time. I was just checking that. We're a little bit before 6. We have one more point on this. It's really brief, and then I'm going to check in before we transition to part 2. Okay. Okay, so the use of office prohibition, I alluded to this before. This is a lot of words up there. This is the analysis when LTD is the source, okay? So gifts are all about a third party, not from LTD, okay? Use of office prohibition means that you can't get any financial benefit or avoidance of financial detriment for yourself or a relative or a member of your household or any business any of those people are associated with that is not otherwise available, okay, except for your role as a board member, okay? There are a couple ways that you can get benefits, but it's if it's adopted through an official process. So like for employees, they can get compensated, right? They're getting compensated and that's not available to the general public, okay? But that's part of their official compensation package. Or like as board members, you would have to take an official action to give yourself a financial benefit, okay? So the general rule is you can't get anything special financially because of your position as a board member. A good example of this is like, you know, you don't get to choose the leftover computers because you're board members, okay? That would be a benefit that you're getting just because you're a board member that's not available to the public, okay? So this just applies when LTD is the source. Gifts are for third parties. Okay. This one doesn't come up very much for board members because you are volunteers. Okay. So I'm going to pause real quick. This is a lot of talking. And I just want to make sure we're doing fine on time. And I just want to quickly pause before we go on to the second part to make sure we're all doing okay. And it doesn't look like we have a question. Okay, so we're going to go on to part 2, and we're doing great on time. Part 2 is public meetings law. I'm sorry that I don't have a pop quiz to communicate this to you, but we'll try to make it as entertaining as we possibly can. Where the government ethics law was at a really high level, you know, we didn't get down into a ton of details, just enough to let you know, hey, I think I remember something about this I need to ask. We're going to go into a little bit more detail for public meetings law than we did in the prior section of this presentation. That is in particular because this board has had a lot of questions about public meetings law. And I can tell that from time to time, some of you have asked me questions and you're not satisfied with the response because it's like, well, that might be, I don't know. And I want to show you why. And so in particular, I want to walk you through the statutes, Oregon revised statutes. We have a handful of cases, the Attorney General's interpretation, and then I want to kind of summarize that to say there's a lot of gray area in this law, and that's why it's hard. And then I want to, even though there's a lot of gray area, I want to give you some tools and some best practices. Okay, so it's a little bit wordy at the beginning. I'm going to try my best to make it not too wordy. I think that it would be best. I think we're going to get clarity as we go through 1, 2, and 3. So I'm happy to have questions throughout on this part, but my preference would be maybe we wait till we get done with 3, because I think that's going to help clarify some things. Okay. So, as I alluded to earlier, this is a pretty hard topic when you get down into it because there is a lot of gray area. And one of the cases that we're going to go over is Dumb Guy versus Handy. And this is a quote actually from that case. And the judge was writing that he was looking for what we call in the legal world a bright line rule, where you have, here's the rule. Here's on this side of it, this is prohibited conduct, and on the other side, it's permitted. And you can walk right up to it and know that you're okay if you're on this side, and know that you're not okay if you're on the other side. And we love bright line rules because we know how to, work within those rules, right? They help us say, don't do this and you can do that, okay? Well, the judge says it would be a fool's errand to try to come up with a bright line rule for public meetings law, and especially the serial communication issue that we're going to get into. And I think what you'll see throughout is because these cases are extremely fact specific, okay? And so it very much depends on the facts of that case. And it ends up leaving us with like a lot of gray area in between like 2 bookends of like, yep, this is prohibited over here and this is okay. And we don't really know in between. And we try our best to make an educated guess, but we don't have a lot of case law on this yet. So I just wanted to start out and like frame our conversation with this quote because I felt relieved when I read this myself. Okay, so we're gonna start out with the Oregon revised statutes, and within some of the Oregon revised statutes, some sections, not all of them, not most of them, but the legislature actually adopts a policy statement. And so the policy statement that the legislature codified into law for the public meetings law is highlighted here. And it talks about, I'm going to point you to 3 things, okay? Deliberations, decisions, and information upon which decisions were made, okay? And it says, it's the intent of this law that decisions of governing bodies be arrived at openly. But they talk about an informed public aware of deliberations, decisions, and information, okay? And so you're gonna see as we go through different interpretations from the court and from the Attorney General about what needs to be done in public and what might not. And I think some of it stems from where that line is drawn, okay? So I would say that if you remember nothing else from the second part of the presentation, remember that this is the policy statement that the legislature tells the court how to interpret these cases. And the legislature has said we want an informed public aware of deliberations, decisions, and information upon which such decisions were made. Okay. So then the part of the law that we're probably most familiar with is a quorum of a governing body may not meet in private for the purpose of deciding on or deliberating towards a decision. So in the prior statute, I talked about 3 things, and here you will see there are 2. So information is not included here. And so for purposes of an LTD board, a quorum is a majority, which is 4 of 7. Okay. And so 4 of 7 cannot meet in private to decide or deliberate towards a decision. Okay. And so then, why is this important? There are very few areas where board members potentially could be subject to personal liability. And why it is so important for me to do this presentation, besides just for you all to know the law, is that I'm making you aware of 2 areas where board members could potentially be subject to personal liability. We talked about that for public, for the ethics portion, okay? You potentially could be subject to personal liability for violating the public meetings law as well. So let's say that 4 or 5 of the 7 board members met in private to talk about how you were going to vote and orchestrated a vote outside of a public meeting. And so orchestrating a vote outside of a public meeting is at the far end, and it's very, very clear that that violates the law, and the court has called orchestrating a vote outside of a public meeting, it makes the vote a sham, okay? And so what can happen? Well, pretty much anybody, any member of the public, it's very broad, this number 2 point, anybody can sue LTD, okay? Anybody affected by the decision, okay? It can make that decision that the board rendered, that sham decision, as the court would say, voidable, okay? And then what the real consequences are is LTD as an entity could be ordered to pay a successful plaintiff reasonable attorney fees. So LTD would have a judgment for money damages against it in the amount of the other side's attorney fees. And if the court finds that the violation of the law was the result of willful misconduct by any member of the board, then the board member could also be held liable for the attorney fees as well. Okay. So like I said, there's not many areas where you have personal liability, and you really need to be aware of those areas. Okay. So that's the bad news, but you need to be aware of it. Okay. So then, this is kind of our story time to go over the cases, which as far as cases go, these are kind of interesting. But in terms of case law, we have really 4 that are applicable. And the last one is important because of the courts holding the decision, but the facts are not as pertinent. So really we're working with about 3 cases. And that is a tiny amount of case law, okay? And so it means that this area of the law is very much still developing, and I very much do not want you as a board to develop it. And so that is why we are having a presentation like this. You will notice that Lane County stars in developing this case law. And so we want to move it away from the Lane County area. So we're going to go through, I'm going to just kind of summarize the cases. The point in sharing these cases with you is I want you to see how much the court's ruling depends on the particular facts of each case, okay? And so we'll move through these pretty quickly. So Harris versus Norquist is our first case on this topic about this portion of public meetings law that we're dealing with. And it is our only court case that we have where the Oregon court held that board's actions were information gathering. And this is where the court makes a difference between information gathering being okay and deliberating being prohibited. Okay, so in this case, plaintiff sued the board of directors of a school district, as well as board members in their individual capacity. And the plaintiffs alleged that board members in numbers sufficient to constitute a quorum met secretly at restaurants to decide school district issues and without complying with public meetings law. So in response, the board members said these were just social gatherings and they only sometimes discussed, and I'm quoting, what was going on at schools. And the court in their holding said, well, just talking about what was going on at schools, that's not deliberating. That's just information gathering, okay? And so that doesn't rise to the level of violating public meetings law. So when you all ask me, what is information gathering? This is the only case that I have on point to use as a reference. And your discussions are probably much more nuanced than what's happening in LTD. They're probably a lot more detailed. That's a pretty high level of discussion. And so this is the only guide from the court that we have as to what is information gathering, okay? So then we have a really long time until we get to the next pertinent case. And this is an interesting case because it's actually a Lane County Circuit Court case that was never appealed. So it is binding law in Lane County, but this court actually this case would not be binding outside of Lane County. However, the analysis was later adopted by the Oregon, either Court of Appeals or Supreme Court. Okay. So this is a really foundational case to understand. And I'm just going to summarize it, and then we're going to talk a little bit about why it's so important. So plaintiffs sued Lane County and 3 commissioners individually. And the court found that a quorum of commissioners, 3 of 5, orchestrated how the commissioners would vote on a pending commission matter. The orchestrating of votes was done via email and a series of meetings, all outside of public meetings. So the actual vote was a sham. And the court concluded that such action was unlawful deliberation towards a decision. This was the first time the court held that we could have what's called serial communications, when board member A talks to B, talks to C, talks to D until there's a quorum, that those could be held when you're not physically in one place at a time. So this was the first time where we had serial communications via email, okay? So I will tell you that this was a very, very fact-specific, very long opinion that the judge wrote. And the commissioner said, well, I don't think that violates the law. We weren't meeting. And the county council, which was ignored by all 3 commissioners who were involved, said, do not try and circumvent the rules, and try to follow the spirit of the rules. And, she was right. So the court found 2 commissioners willfully violated the law. And so the result was that Lane County had a $350,000 judgment entered against them. And commissioners Handy and Sorensen had $20,000 judgments entered against them individually. And so this was the case that gave us that serial communication. Like I said, board member A to B to C to D, they may have never been in the room at the same time. Okay, you can do it by phone, you can do it by email, you can do it by text. This was the case that gave us 4 of you doing that. To deliberate towards a decision would be a violation of public meetings law. And so this was just a really foundational case that, I can't really overstate the importance for what it did in this area of the law. Okay, so that was Dumdye versus Handy in 2011. And like I said, that case still stands, but it was settled before appeal. Okay, so now we go, if you'll notice, there's one player that's still the same, Handy versus Lane County. Okay, so from our 2011 case, Handy was one of the 2 who had a $20,000 judgment entered against him. So the story continues. So as a result of that case, he had a $20,000 debt to Lane County. and he was running for re-election, and he was seeking contributions to pay off his debt. And he was asking donors to make contributions to Lane County for his benefit to reduce the debt. And Handy contacted some business person to make a contribution. And that business person thought that asking to pay down the debt was a violation of the law. So he contacted his attorney, who in turn notified a whole bunch of government entities about Handy's request for a donation to pay off this debt. And one of those entities was the Lane County District's Attorney's Office. So within like 2 hours of the Lane County DA and Lane County receiving the letter from the business person's attorney, there was a public records request for the letter from the media. So the county administrator emailed 2 commissioners regarding receipt of the letter and her suggestion that the letter be disclosed. And then in addition to emailing those 2, she spoke with the 3rd. And so one commissioner expressed concern about the county's financial liability in regards to this letter and Handy seeking contributions. But other than financial liability, he didn't talk about whether the letter should be disclosed. And then commissioners 2 and 3 also responded with the same concern about the county's financial liability via email, but they did not express any statement about whether the letter should be disclosed. The next day, very early in the morning, they had a public meeting where they voted to disclose the letter in response to the public records request. So the court held that, yes, they talked outside of a public meeting, but whether the county could have financial liability is not deliberating towards a decision, because their decision was whether to release the letter, okay? And so my point here is that they're just a really, really fact-specific analysis, okay? And that's part of what makes it hard that we're just not gonna get this bright line rule, okay? So I have one more.
Wait, hold on. Sorry, Kristen, just before you move on from that, let me make sure I understand the punchline. The punchline is that because they were talking about something that was so narrow and it was not any sort of council or commission deliberation, ultimately it was deemed okay in this narrow.
That's right. Yeah, that's right. Yeah. Okay. So then our most recent case that we have on this, TriMet versus ATU from 2019, the facts are really not helpful to the discussion. They're totally different, but it's legally important because this is the first time the Oregon Supreme Court holds that a quorum of a governing body can meet for purposes of public meetings law via serial communication. So that's, you know, meetings, email, messages back and forth, phone, text, whatever. And that if those add up to quorum, it can become a violation of public meetings law, okay? And so that the Supreme Court in 2018 basically adopted the Lane County Circuit Court analysis from that 2011 court case, okay? So that's the kind of universe that we're working with. So we've gone over the statutes, we've gone over the case law. We're still doing good on time. I'm gonna make it before 6:30. Okay, so this is a ton of words. This is and I'm gonna summarize the Attorney General's interpretation. So court cases are legally binding. The Attorney General publishes a manual about public meetings law, and it is persuasive authority. A court would not have to legally follow it. However, a court may find it persuasive. And so the Attorney General takes a much broader approach to what needs to be done in public. And the Attorney General, their approach and their interpretation is that the public meetings requirement applies to information gathering and discussion of business. So I'm just gonna read some of the underlying portion. Even if a meeting is for the sole purpose of gathering information to serve as the basis for a subsequent decision or recommendation by the governing body, the public meetings law will apply. Members constituting a quorum must avoid any discussions of official business during such a gathering. And then they go on to say, we recommend members of a governing body should not meet in private to discuss business or exchange private communications about business, even if those involved constitute less than a quorum. So this is way broader than what the court has ruled. So far, you know, in the really narrow universe that we have, the court is focusing on, are you deliberating towards a decision, okay? However, the court case law is still developing. It looks like they're focusing on that narrow thing, right? Setting up a sham vote, but we also have this out here. And I want you to be aware that the Attorney General's interpretation is a lot broader, okay? So I want to get to this next slide to give a visual of here we are, okay? We have at one end in this big green things that are totally fine and are not anywhere near the gray area. And there's not a lot of them. And it's, you know, purely social discussions, what I like to call procedural things like scheduling, availability, stuff like that. And then we have at this other end, what we know is clearly prohibited, which is orchestrating votes, saying, hey, will you vote this way because, you know, if you vote this way on this thing, I'll vote this way on this thing, and doing that among a quorum of you so that when you go into the meeting, everything's prearranged, okay? That is clearly prohibited. And then we have what I think is a tremendous gray area in which a lot of business probably gets done that the court has not really analyzed for us. But the court, I think, is tending to draw the line over here, okay? That's what it's looking like, closer to this line. But the Attorney General is trying to draw it way over here, okay? And so we just have this big area in between about, you know, is this okay? The Attorney General says it's not, but the court might say that it is okay. And so this is really where, you know, this is why it becomes hard in addition to the analysis is so fact specific, okay? So one thing that I'm gonna go on to the tools in the toolbox and then we'll talk a little bit more after that. Okay, so again, I don't wanna just leave you with like, oh, this is hard. There's a lot of gray area. I wanna give you some tools so that you can be aware of how to function and maybe what the risk level is associated with those types of communication. So I gave you 5 tools. I actually talked to several attorneys in town who practice municipal law and just talked about how their boards or councils or whatever handle this. And so there's not mysterious tools that we're missing. This is the universe of tools. And so we'll go through each one of these. Obviously, your board meetings and your work sessions are the most publicly oriented type of communication, and that's where most of your communication should happen, okay? So then we get down to this getting a little bit gray, but still really close to the green area. So one tool that a lot of boards use and LTD is used from time to time is meetings or conferences with the general manager or CEO person for information and as a check-in. And so something important to note is that meeting with, you know, talking to me about something, you can never form a quorum with me, okay? You can never form a quorum with AJ or with staff. You can only form a quorum among LTD board members. So if you need more information about a topic, talking to AJ is never going to get you to serial communication. She's not going to relay serial communication. So getting information from AJ is not going to get you into this. And so that's why it's a great resource to use your staff, your CEO level person, because the public meetings law analysis does not apply to her. Okay, so that's tool number 3. Tool number 4, we're getting a little further down. Board members talk outside of public meetings on an as needed basis for information sharing and never more than a quorum. Okay, So number 4 needs to be used with extreme care, okay? Because you and I probably don't know exactly where the line is about what is information sharing, okay? So that's one of the dangers of this, is that we don't have a great definition for information sharing, okay? The second piece is that it is not totally clear that if we go all the way back to the beginning about having an informed public, aware of the deliberations, the decisions, and the information upon which it relies, those 3 things. If you're doing information sharing outside of the public sphere, does that meet the policy statement? So far, the court hasn't seemed to take that into consideration, but the Attorney General definitely has, okay? So there are some risks that are associated with number 4, but so far it seems in the gray area and not clearly prohibited. Number 5, if ever used, it needs to be used with extreme care. Okay, so this is board members talking outside of public meetings to deliberate towards a decision, and never more than a quorum. If it's a quorum or more, you're in violation of the law. Okay, here's what I will say about number 5. I know that this happens. I know it happens on every single board. I know board members want to talk to each other about, you know, what are you thinking about this? What are you thinking about that? Okay. The concern and the problem is that you could inadvertently be part of a serial communication. So you might just be, you know, board member A, and you think you're only talking to board member B. But then board member C calls board member B about the same topic. And then board member C calls board member D. And you were board member A and you thought you talked to one person, but you're involved in a chain, okay? So, you know, I know that this happens, you know, there's just significant risk because of that issue, okay? And I just need to make sure that you are aware of that risk. It's your decision. You just need to be aware of that risk. And then the second piece is, you know, again, just like number 4, it's not clear that that complies with the policy statement. So we go all the way back to that, and inform public aware of decision, deliberation, and information. So are you having a deliberation outside of the public sphere? You know, the court, again, hasn't really looked to that. The court has tilted more towards that far side. Okay.
Kristen, I just want to give you a heads up. We're pretty much getting close.
Yeah, I've left one slide. Okay, so sorry. Okay, so here are my best practices and recommendations based on those tools. Avoid discussing substantive matters outside of public meetings, absolutely with a quorum. Avoid forwarding emails among board members or replying all, okay? The serial communication, avoid discussing a district matter with one director and then speaking on the same matter to another one. Don't do that, because if both of you do that, you have your quorum. We really don't like polling outside of meetings because it's not clear that that's permissible. So if you're trying to take the temperature of the board to say, how do you think you'll vote? We don't know if that's information gathering or deliberation. And so then last 2 points, you know, we don't want you to get into trouble on this issue. It harms you all and it harms LTD. So, you know, work with us and your general manager. And my last piece is what we talked about in the first part of the presentation. This is not a presentation about public records law. However, remember that everything you put in writing in your role as LTD board member and related to LTD, even if it's in your private email, even if it's in your phone, could potentially be subject to a public records request, okay? So be really, really careful about what you write down because, you know, always think about what if that's on the front page of the Register Guard? Would I want that to be there, okay? So that took up like our whole time, I'm sorry. I don't know if we have like 1 or 2 minutes for questions. But I'm happy to be a resource however I can.
Josh, do you want to say something?
Yeah, super duper fast. First of all, Kristen, for the benefit of our new board members, it would be great if you could just send, and reminder for everybody here to send around the memo or two that you've produced for us over the last couple of years. You had really lengthy but really intelligible summaries of what we know on this stuff, and I sort of keep that stuff handy. I think everyone would appreciate that.
Sure.
The second thing I would just say to everyone, I think it's important to think about the principles that Kristen mentioned. And actually, the one time that we can never get in trouble for deliberating and for having discussions amongst any number of us is when we are doing it in public. And that is not just one of the ways that we can avoid breaking the law, but it might be the way we do our job. So I would encourage us to think about more and more vigorous public discussion as a big part of what we're actually doing.
Josh, that's a really good point. And I think, everyone heard when I asked everyone to make sure you are reading your agendas ahead of the meeting. And those two things really tie together. Coming into a meeting, having questions, feeling knowledgeable about a subject really helps those discussions be robust and just more productive rather than just asking kind of surface questions if you're unfamiliar with the material. So I just take it really serious that everyone is always coming to every board meeting and work session, having read the packet and being prepared. Those are the expectations there. And then Stephen has his hand up.
Thanks,
Stephen.
Caitlin. Thanks, Caitlin. Appreciate it. Just quickly, again, Kristen, thank you for this. This was helpful. It clarified some key things. And I just want to quickly say welcome to Susan and welcome to Michelle. Looking forward to working with both of you, and welcome to the board. I'm sure you've raised the intelligence level greatly, so welcome.
Awesome. Well, Kristen, you did a great job. You had a good pace this whole time. Should we be doing more board meetings with a point system and rewards sent out? You really got me thinking. What
I felt very lost without an ability to bribe people with candy.
You make a great lawyer then. Yeah. Well, in all seriousness, you did a great job. This was great information, and it's always a good refresher for everyone in this group, and just a huge round of applause for you on all of this. So thank you for taking the time to do this evening. And as always, I encourage all board members, if you have additional questions, please reach out to Kristen directly. She'd be happy to answer those. And we want to make sure everyone's moving forward, feeling very well informed and comfortable and confident in your role. So if there's something you want to ask in private, please, or to Kristen, which we now know it's not necessarily private because it's, on public record, but please do reach out to her. So with that, I am going to conclude our meeting for this evening and adjourn us, and I will see everyone in 2 weeks. Thank you so much, everyone, for your time this evening.